Welcome back to the Deep Dive. Today we're tackling Forcible Detainer in California. We've got legal guides and some real-world examples to help make sense of it all, what it is, how it all works, and why it matters, even if you're not a landlord or a tenant right now.
Yeah, it's kind of interesting how that term forcible detainer, it sounds a bit dramatic, doesn't it? But here in California, it often boils down to a very specific type of eviction.
So we're not talking about a landlord like breaking down a door to get their property back.
Not exactly, no. Forcible detainer usually comes into play when someone's living in a property without having legal permission to do so, even if they were a legit tenant at some point.
Right. So it's like that guest who just won't leave a party even after the music's off and the snacks are all gone.
Yeah, that's a perfect analogy. Like, think about when a lease expires and the tenant just won't move out, or someone's living there without any lease at all.
So it's about getting the property back. When someone's basically squatting, right, regardless of why they were there in the first place.
Exactly, you got it. And the process here in California, well, it has some things in common with regular eviction, but it's got its own little twists and turns for sure.
So let's break it all down. Where does this forcible detainer journey begin?
Well, it all starts with a notice to vacate. It's basically the landlord's way of formally saying, hey, it's time to move out.
That's got to feel pretty serious, right? It's like getting an official eviction notice.
It is, yeah. And there are actually different types of those notices, depending on what's going on. You've got the pay, rent, or quit notice. Pretty straightforward.
Yeah, that one seems pretty obvious. Pay up or hit the road.
Right, exactly. Then there's the cure or quit notice. This one's used when a tenant's violated part of their lease, like maybe they damaged the property or got unauthorized pets. They get a chance to fix the issue or move out.
So it's kind of like a second chance before getting evicted.
Exactly. And then there's the notice to vacate without cause. This one comes up when a lease is ending and the landlord doesn't want to renew it, or sometimes when they want the property back for their own use.
Interesting. So even if you haven't messed up, you could still get this notice.
That's right. California law allows for that in certain situations. Maybe we can dig into that more another time. But the main point is, this notice to vacate, no matter what kind it is, it's that crucial first step in this whole forcible detainer thing.
It's like setting the legal wheels in motion.
Exactly. And it has to be delivered the right way to be valid, like personal delivery, posting it on the door, or certified mail, depends on the situation.
So then just slipping a note under the door or sending a casual text.
Nope, not if you want to do it by the book. There are legal rules to make sure the tenant knows what's up and has a fair chance to respond.
Okay, so let's say the tenant just ignores this notice. I'm guessing things get more serious then, right?
You got it. If they don't do what the notice says within the time limit, the landlord can then file a forcible detainer complaint in court. This is the official document. That really kicks off that eviction process.
So now it's getting real. Like moving from a reminder to a full-blown legal battle.
You could say that. The complaint lays out all the details about the tenancy, why they're being evicted, and proof that they got that notice to vacate properly.
It seems like having a lawyer would be super important here for both landlords and tenants.
Absolutely. Landlords need to make sure their paperwork is all good and that they're following the process correctly to have a good chance of winning. And tenants need to understand their rights and how to defend themselves right from the start. A resource like martinezlawcenter.com could be really helpful here.
So the complaint is filed. Then what? What's the next step in this legal dance?
Well, the court schedules a hearing. Usually within a few weeks, both the landlord and the tenant get notified. And this is where they both get to tell their side of the story.
Like a courtroom scene in a movie, where everyone gets their say.
Yeah, kind of like that. But remember, this is real life, and the stakes are high.
So it's not just about giving a good speech. What kind of evidence is usually presented at this hearing?
The landlord usually shows things like the lease agreement, the notice to vacate, and any other documents that back up their claim, like maybe proof of unpaid rent or evidence of those lease violations.
And what about the tenant? What can they do to defend themselves?
They can tell their side of things, offer their own documents, and maybe even raise counterclaims. Like, they could argue that the landlord didn't maintain the property well, or that they didn't get that notice the right way.
So it's back and forth, both sides trying to convince the judge that they're right.
Exactly. And the judge has a really important role. They have to look at all the evidence and arguments before making their decision.
It's like the judge is the referee in this legal boxing match, making sure everything's fair.
Good analogy. And this is where things can get interesting, because the judge's decision has a big impact on both the landlord and the tenant.
Sounds like this hearing is a make or break moment in the whole process.
It really is.
I think we should dig into what can happen after that hearing. after we take a quick break. Stay tuned.
So we left off talking about that court hearing. It's a pretty crucial moment in the whole forcible detainer process, right?
Definitely, yeah. It's where both sides lay it all out.
Right. After hearing everything, the judge is going to make a decision. They'll issue a judgment saying whether the tenant has to leave or not.
So it's the moment of truth, like waiting for the jury to come back into trial.
Yeah, you could say that. If the judge sides with the landlord, they'll issue what's called a judgment for possession. Basically, it's a legal order saying the tenant has got to go.
So that's it then. Game over.
Well, not always. Usually, the tenant has a right to appeal, meaning they can take it to a higher court and try to get that judgment overturned.
So there's still a chance to fight back. But I bet that gets even more complicated legally.
Oh, for sure. Appeals can be tricky. It's usually a good idea to get a lawyer involved at that point, someone who can navigate the process and make sure the tenant's rights are protected.
Again, it shows how important it is to have good legal help. Throughout this whole forcible detainer thing.
Totally agree. Whether you're the landlord or the tenant, knowing your rights and what you can do is super important.
Okay, so let's say the tenant doesn't appeal, or they do, and it doesn't work out. Is that when the eviction actually happens?
Yep, you got it. If the tenant still won't leave on their own, after all that legal stuff, the landlord can get the court's judgment enforced through a formal eviction.
So this is like the point of no return.
Pretty much. And it's important to understand this part involves law enforcement. It can be really stressful for everyone.
Yeah, I can imagine. Can you walk us through what actually happens during a formal eviction?
Sure. It starts with the landlord asking the court for a writ of possession. It's a document that gives law enforcement, usually sheriff's deputies, the authority to remove the tenant from the property.
Wow, so they bring in the big guns.
It is a serious step. It shows how important it is to try and resolve these things peacefully if possible.
So they get the writ, then what? Do the deputies just show up and start moving people out?
Not right away. The tenant gets one last notice, telling them when the eviction's going to happen, usually a few days after they get served with that writ. Then, on the scheduled day, the officers come and oversee the whole thing, removing the tenant and their belongings.
Sounds pretty intense.
It can be, yeah. It's a reminder that even though we're talking about legal stuff, there are real people at the heart of it all.
Absolutely. We've talked about the steps involved in all this, but I'm curious about some real-life examples. How do these situations actually play out?
Yeah, good point. It's always helpful to see how this stuff works in the real world.
Exactly. So what kind of scenarios would trigger a forcible detainer?
One common one, like we talked about before, is when a lease just ends and the landlord doesn't want to renew it. But the tenant, for whatever reason, doesn't want to leave.
Like that guest who just won't take the hint at the party.
Yep, exactly that. The landlord has said it's over, but the tenant's still there without permission.
So in that case, the landlord would use forcible detainer to get their property back.
Exactly. It's about protecting their rights as the owner. When someone's living there without a legal agreement. I saw another good example on Mary Catherine Wiederhold's legal website. Imagine a tenant gives notice they'll move out by the end of the month. But when that day comes, they're still there.
Oh yeah, I've heard those stories. It's a nightmare for landlords who have new tenants lined up.
It definitely messes things up. In that case, even though the tenant gave notice, they didn't actually leave when they said they would. So they're basically there without permission.
So even with that initial notice, if they don't actually move out, they become a holdover tenant.
Exactly. And that's when forcible detainer might be necessary to get things sorted out legally. It just shows how important communication is. And sticking to agreed upon timelines in any landlord-tenant situation?
For sure. These real-life examples really drive home the point. Why it's good to know about forcible detainer, even if you're not a landlord or a tenant right now in California.
Absolutely. Just having a basic understanding of this stuff can be really helpful, whether you're renting, own a home, or just want to be more informed about real estate in general.
It's like having a cheat sheet for all this legal stuff.
I like that, a cheat sheet. And of course, for actual landlords and tenants, it's even more important. Knowing your rights and responsibilities under the law can make a huge difference in protecting yourself.
It's all about avoiding those costly mistakes and legal battles, right?
Exactly. And remember, knowing is half the battle. If you're ever facing a forcible detainer situation or any other complicated legal issue with real estate, the best thing you can do is talk to a lawyer.
Yeah, for sure. And for our listeners who need some expert guidance, a great resource is martinezlawcenter.com. They focus on California real estate law. And can give advice tailored to your specific situation.
Before we move on, there's one more interesting thing about forcible detainer in California. It's that tenants have limited options for defending themselves. They can't just say the landlord doesn't actually own the property, for example.
Really? So it's more about whether they were allowed to be there at that time, not about whether the landlord has the right to own the property at all.
Exactly. It comes down to if they had permission to be on the property.
That's an important distinction. It really highlights that forcible detainer is about getting the property back when someone's overstayed their welcome, no matter what the reason is.
You got it. That's what makes these cases so unique and often pretty complex from a legal standpoint.
Well, I've learned a ton about forcible detainer today. It's definitely more relevant and nuanced than I thought.
Glad to hear it.
I think it's time to wrap up this deep dive and leave our listeners with some final thoughts to chew on.
I agree. We've covered a lot, but I think it's important to acknowledge the human side of all this.
Yeah, you're right. Forcible detainer cases are about property rights, but they can really impact people's lives, both landlords and tenants.
For sure. And as we've seen, these cases often come from misunderstandings or things that just didn't go as planned. It's a reminder that clear communication and respect and being willing to compromise can help prevent things from turning into legal battles.
Well said. I think that's a great note to end on. Remember, knowledge is power. Understanding your rights and options is the first step in navigating all this legal stuff.
Couldn't have said it better myself.
So until next time, stay curious, stay informed, and keep those minds working.
And if you need expert legal advice on forcible detainer or anything else related to real estate in California, be sure to check out martinezlawcenter.com. Their team can give you the guidance and support you need.
Absolutely. Thanks for joining us on the deep dive.
Even though we've been talking about forcible detainer and the legal steps and all that, I think it's worth stepping back for a minute and thinking about why this matters, even for people who aren't landlords or tenants.
Yeah, you're right. We can get caught up in the details.
Exactly. Understanding this stuff. It's not just about knowing the law. It's about understanding something really fundamental about how our society works, the relationship between property owners and the people who live there, whether you rent, own a home, or just care about housing. This is relevant.
It's about recognizing both sides.
Right.
The rights and responsibilities of landlords and tenants, and how those interests are balanced legally.
Right, exactly. And recognizing that these legal processes, while they're meant to make things clear and fair, they can really impact people's lives.
That's a really important point. Behind all the legal terms and steps, there are real people with their own stories and struggles. Getting evicted can be a traumatic experience, no matter what led up to it.
Absolutely. We're not just talking about abstract concepts here. We're talking about people's homes, their sense of security and stability.
And on the other side, landlords have their own interests to protect. They rely on rent to cover their costs, and they have a right to get their property back. When a lease ends...
Yeah, for sure. It's about finding that middle ground, protecting property rights while making sure tenants are treated fairly and have due process.
It's a tough balance to strike.
It is, and it's something that's always being debated and adjusted in our legal system.
Exactly. Laws and regulations change over time as society changes. Landlord-tenant law is no different.
Right. What might have been okay years ago might not be okay now.
It shows that learning is an ongoing process. We should always try to stay up to date on these things, whether it's through online resources, legal experts, or community groups.
Absolutely. I think that's a great takeaway from our deep dive today. Forcible detainer in California is complex. It has real-world consequences. It's something we should pay attention to and think about.
I agree. I hope our listeners feel empowered to learn more and to seek legal help if they need it.
And remember, knowledge is more powerful when we share it. Talk about these issues with your friends, family, and community. The more we understand about these legal processes, the better we can advocate for fair housing policies.
Well said. So, until next time, stay curious, stay informed, and keep those minds engaged.
And if you're looking for legal advice on forcible detainer or any real estate matter in California, check out martinezlawcenter.com. They have a team of experts who can help.
Absolutely. Thanks for joining us on the Deep Dive.
Call now 714-442-9741. Thank you.